The following news flash is brought to you by the Lone Star Lowdown, providing your daily bulletins for the commodities market. Today in history, news updates, and the inside scoop into the tides of the alternative. Markets for the 6th of January 2016 open up with gold at $1,093.40 an ounce, silver $13.99 an ounce, Texas crude $35.97 a barrel, and Bitcoin is currently at 431 U.S. currency. Today in history, Monday, January 6th, 1958, Gibson patents its Flying V guitar, an electric guitar model with a radical futuristic V-body design. In recent news, here at the Lone Star Lowdown, we pride ourselves in bringing you the headlines of the day without the hype and media bias. As a result, we are always having to correct the narrative. So to cut to the chase, we are sorry for reporting some falsehoods yesterday. The Bundy situation in Oregon is not a standoff or occupation. According to the Citizens for Constitutional Freedom press conference, they are simply reclaiming the federal wildlife refuge for the state of Oregon and its citizenry, specifically all the ranchers that have had to give up lands to the BLM. Dwight Heyman and his son, Stephen, are facing terrorism charges and resentencing. The point of the land burns, which eventually spread from their land to federal lands, was for ranching purposes and not agricultural reasons. We are sorry for the incorrect reporting of the other day. Regardless of who drops the ball, the media or even ourselves, we're always here to correct and clarify. The TransCanada Corporation has filed a lawsuit in a U.S. federal court in Houston, Texas, stating that President Barack Obama's ban on the Keystone Pipeline supersedes his legitimate powers within the Constitution. Through a NAFTA claim, TransCanada is seeking to receive compensation for more than $15 billion in the expenditures and damages it has accumulated as a result of the permit ban. Governor Jerry Brown declared a state of emergency today, ordering California state agencies to move as rapidly as possible in fixing a gas leak which has been spewing 110,000 pounds of natural gas per hour since October of last year. This declaration comes after previous attempts to plug the leak of methane have failed. He stated that, quote, 7 state agencies are mobilized to protect public health, oversee Southern California's gas companies' actions to stop the leak, track methane emissions, ensure worker safety, safeguard energy reliability, and address any other problems stemming from the leak. The Lone Star Lowdown is currently looking to fill some advertisement slots. So you have a product or a service you'd like to advertise with us, feel free to give us a call at 210-363-2257. This has been your Lowdown for January 6, 2016.
Well, I received my remedy today. Came in the box, just like they say. I accepted it for value right away.
Okay, we are back. Randy Kelton, Rule Law Radio, and we're talking to Truth Raider in Oregon. Okay, what else do you have for us?
Well, I got a couple of things. I got the two different subjects. I want to just give you an update of what's going on with this, which seems to be a bit of good news concerning, renting in the business of rental properties, etc. But the good news about that is that in the future, the governor of Oregon, Kate Brown, took some legal action, and it was on our local news here during the summer. I missed it. I didn't see it. I was busy going from place to place until I got moved in here to the house here. And she's put some type of an injunction against landlords, sort of some type of a hold that they're not allowed to put people out without giving a written reason, without a cause. And instead of 60 days, she moved to force them to give the tenants 90 days. To be able to move. So that's the good news concerning that.
Well, that will certainly change the calculation, because if you're up in the rent, let's say you're paying $500 a month for rent, and they want to up it to $550. So they give you 3 months. They have to give you 3 months to move, and you're going to stop paying. So it's going to cost them $1,500 to get you out of there. It's going to take them 2 years to collect that $1,500 they're going to lose back.
Right.
So it sure changes the calculation quite a bit.
Yeah, the hypothetical scenario. Yeah, well, I paid my rent in full, and they gave me a full refund. They tried to charge me for a couple of extra things and repairs, which were non-existent. They were going to charge me for a new carpet, but the carpet was old when I first moved in there, so they reversed that, and they gave me back my deposit concerning the carpet. So I just wiped my hands clean of that. So that's the good news about that. I'm done and finished, and I don't think I have any legal recourse in any other way, concerning trying to find some liability on their part for doing what they did, because it is their property, and at that time it was prior to the governor getting involved in this. So I don't think I can do anything retroactively against them concerning that. But that's not my biggest challenge. My biggest challenge is this. I've been calling Eddie for quite some time, and I think he's maybe a little tired of me, maybe a little frustrated with me. Doesn't feel that I'm really doing my studies, doing things I need to do. So it's difficult. I want to maybe talk to you a little bit about it, about the transportation code and what's going on, and with the vehicle code. I received my first ticket in June of last year, and I just I did the best I could in court, to motion to dismiss. Where do they have jurisdiction over private travelers when I'm not in the contract? Reveal to them information that proves that the vehicle code and the Oregon revised statutes is all concerning transportation, and driving is all commercial. But it didn't matter. They just listened to it. All right. Well, I go ahead and the judge said, I'm going ahead and find you guilty of driving while suspended and driving without insurance. So it didn't matter anyway, no matter what I did. So, I just said, well, I motioned to disqualify, and they won't let me do that either. So I just let it go. I didn't sign any paperwork. I said, I refuse, and I'm looking to appeal. So,
did you appeal?
They wanted me to post all the money up front, and I didn't have the money to do so.
Did you file informa pauperis?
No, I didn't know where to go to find out where I can get that or where I can do that.
Did you learn anything?
Yeah, I learned that it's a kangaroo court. They have a script, what they read.
Okay.
And no method.
Wait a minute. You got to understand, and we keep saying this. The trial court, your only purpose is set the record for appeal. If you're going to fight this thing, then you have to be prepared for appeal.
Right.
The only purpose in the trial court is to set the record. You don't care what that jackleg does.
Yeah.
And if it's traffic,
that was last summer.
You don't care what. You don't even have to set the record.
Right.
You can just tell him, knock yourself out, have fun. We'll take this to the appeals court and fight your fight there. But it's worth it to fight the local court, because you get a better idea. You get some experience handling yourself in court.
Right.
And once you get the rubber ball theory down, you go in there and really work them over.
Okay.
It's a lot more fun when you start jerking them around. Okay, what else do you have for us?
Well, I don't know if I expired my time, as I'm out of the time frame, if my statute of limitations is over for me.
How old is the ticket?
Oh, that was in June, and I got to go to court on it for the first time in August, and then in September was my trial. And
okay, then you generally, like Texas, you got 10 days to appeal, and the maximum you're going to have to appeal is 30 days. So I would say your time is up.
Okay.
I'm also going to say,
okay,
pick your fights real careful. If you're going to get into one of these fights, don't wait for them to bring the fight to you. If you want to have the fight on these issues, you go pick it. Works a whole lot better when you pick the fight.
Okay. Well,
and pick a fight you want to have and that you're prepared for.
All right.
And it's great fun. And once you start working them over good, they don't want you in their court for anything else. I had a sheriff's deputy come to me, and he said, "What'd you do to the sheriff?" And I said, "Well, I hadn't done anything to him lately. Why?" He said, "Well, we had roll call this morning. He asked who here knew Randy Kelton." He said about half of us raised our hand, and the sheriff said, Look, you are not to stop him. You are not to cite him. And whatever you do, don't put that SOB in my jail." You give them a good fight, they don't want anything to do with you anymore.
Well, that would be my ultimate goal. I'd love to be able to say that I could, stand in the same shoes that Randy Kelton got that special.
You have to. A lot of the fights I've had with him, I picked them. I went down to the prosecuting attorney and requested information under the Open Records Act. And he hopped up and down, railed in righteous indignation, and objected to the attorney general. And I filed a response to his objection, and the attorney general told him to give it to me. So he is furious. And I go down there to get it, and I'm sitting down reading the documentation. He told me I had to get out of the office, and I told him, beat it. He got real excited, so I called 911. And while the prosecutor's screaming at me in the background, I'm asking the 911 operator to dispatch somebody to arrest him, because under the Open Records Act, he's to give me all facility and comfort in the examination of the records. And he's trying to throw me out in the street. So
Wow.
that's what I wound up getting the district judge, because the sheriff refused to dispatch, and I was in the judge's court. It was empty, talking to the head bailiff at the direction of the high sheriff of the county, making a criminal complaint against the district attorney. And the judge come running in. Mr. Kelton, you're creating a disturbance. You get out of this courthouse or I'll have you arrested. And I said, oh, gee whiz, Judge, I'm sorry. And I reached in my pocket and I jerked out this little digital recorder, poked the button on it, stuck it in his face and said, will you say that again? Oh, he just stood there huffing and then spun around and charged out of there. I charged him with making a terroristic threat and filed it with the Attorney General. Oh, that was so much fun.
I can see me doing that sometime in the future once I get all the knowledge I need. I get good at this. You know, when I reach
did you listen to the rubber ball theory portion?
Yes, I did. That was interesting. Yeah, I appreciate your diatribes. And
go back and listen to that again, and then you listen to the stories that I tell. I mean, that one right there. That's what I'm doing. When that judge come charging in there or threatening to have me arrested, oh, I'm sorry, Judge, and I snatched that little recorder out of my pocket and poked the button on it. He just stood there frozen in his tracks. And I know what he's thinking. That darn prosecutor, he didn't tell me everything. But he was interrupted. He was stopped in his tracks. Most every story you hear me tell, it involves interrupting him. And it is very powerful. Once you get that part down, then we get to some really sophisticated linguistic structures that'll make them nuts. Objection, Your Honor, assumes a fact not in evidence, contains a distortion, deletion with a distortion, deletion by, what's the term? I had it to, this is a missing operative. I'll have to go back and reread it. I need to present this because I need to study it more. These things, they're really sophisticated. And I was trying to think of as a lost performative. They're not going to know what a lost performative is, but once you begin to understand these structures, you'll be able to take their language apart in a way that they don't even understand. Lost performatives, for the most part, the prosecutor is not going to know what it is. You know, you'll get guys on the show sometimes. I call the guys preaching patriot mythology. And they say, oh, well, in 1931, there was a bankruptcy, and therefore you can't pay your bill. You can't pay a bill. You can only extinguish it. And I want to objection, lost performative. How did you get from this place to the second place? Because they'll make that jump, and then they'll do another one and do another. This is the case, therefore that's the case. This is that. Since that's the case, this the case, this the case. Keating, I looked on his website, first page. I'm 6 presuppositions in for him justifying his point, and I didn't buy the first supposition because it had a lost performative. Lost performative. When you claim something is so and you don't show how it is so.
Right.
Never make a proactive statement of law out of your own mouth, because if you do, it has a lost performative. When you start sticking these down those judges' throats, they're going to go bonkers. Okay, do you have anything else for us? We're about to go to break.
Yes, I do. I have some questions for you, Randy.
Okay. We'll pick it up on the other side. Randy Kelton, Real Law Radio. We'll be right back.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Well, don't let nothing get to you. Only the Father can deliver you. So don't let bad mind people hurt you. Until Satan get behind you.
Okay, we are back. Randy Kelton, Real Law Radio. We're going to Truth Raider in Oregon. Hello, Truth. Hello, Truth. Are you there? Well, looks like we may have a problem with your call. Truth, will you call back in? I think your line is dropped. Okay, we're going to go to Mark in Wisconsin. Hello, Mark.
Hello, Mr. Kelton. How are you this fine evening?
I am wonderful. I don't care what everybody says.
All right.
So, have you been having fun here lately?
Well, it all depends on who you're going to ask. If you ask the attorneys I've been dealing with, no, I'm not fun. You ask me, I'm just a barrel of joy.
I kind of suspected that. So what have you been up to?
Well, I've been trying to make a little bit of trouble for a public defender. He managed to get a public defender managed to get a case involving a person that I know, and I'm being asked to help this guy. And of course, I can't really do a lot. For one thing, he can't say anything to me because I'm subpoenable. I'm not an attorney. So
hold on. He can't say anything to you because you're subpoenable? Are you a witness in the case?
I'm not a witness in the case, but if he tells me anything about what's going on with details that aren't part of the public record of that, I could become subpoenable, can't I?
No. Anything he tells you is hearsay.
Oh, well, all right.
Well, yeah, maybe you are subpoenable.
Yeah, it's best for me to avoid the situation and him also.
Yeah.
The way I'm approaching it. But in the process, he said, what can I do? And I said, well, why don't you create a couple of motions? One motion, move to dismiss the case. I mean, he wasn't even, they hadn't even gotten through the bail part and everything else. He put in a motion to dismiss with no supporting evidence whatsoever. And I said, they're going to bounce that. It's garbage. And he said, the other thing, though, and this one isn't that garbage, ask for co-counsel for the public defender. And oh my goodness, what anger from the public defender, according to this gentleman. Public defender went so far as to say, are you ready to try this case tomorrow? Because tomorrow happened to be the next hearing day. And it was the first day the public defender had actually met with him. So I told him about the wonders of Wisconsin SCR 20.
You didn't have that guy bar grief, did you?
I suggested that, perhaps what he should do is have sheets of paper with him, and as things happen, he writes down the stuff as he feels he's being aggrievable offenses happen. And I suggested, maybe you type up all your bar grievances and have a folder with you. And, you're absent-minded. If you left the folder behind and came back a half hour later, oh, well, that's, you're absent-minded, la-di-da. So that fun is just starting there. I finally have gotten the go-ahead to work with going after the law firm that originally created all the problems when I started calling you back in 2012. That law firm, the group of people who are actually a paying customer, wrote them a letter saying, we want our files, and they wrote back a one-page, two-paragraph letter going, you're not our customer, we have no files of yours. Sure, we're working on that as a bar grievance, but, to create a little bit of politics because, we like doing that. I reached out to not only the lawyer who left the firm, but the boss who left the firm and said, yeah, while you'd left the firm and these requests were made, probably after you'd left, what I want from you is your insurance, the name of your insurance carrier. And then to the boss, I said, as a boss, you understand. Sometimes you've got to, go up the chain of command. We've tried 2 different times to have these people give us our paperwork, and asking a third time doesn't seem to be productive. So I'm asking you to look into this matter, think about it, and get back to us. So that was sent around 4 p.m. today. Give them all something to think about this weekend.
So he's looking at, did you happen to mention respondeat superior?
I did not mention respondeat superior. I did. I figured just asking for, okay, who's your insurance carrier ought to get them all their underwear cinched up a couple of notches.
Good chance it did.
I'm not sure they have any obligation to turn that information over, though. But
if it was a client record,
yep.
Even if he's not a client now, if at the time it was a client record, they have to turn it over.
Okay.
Well, at least it's in the American Bar Association model standards.
All right.
That they absolutely have to, or that's a grievance.
Right.
And if those documents belong to the litigant, not to the lawyer.
Mm-hmm.
They're private property of the litigant.
Wonderful. All right, so we got the grievance stuff there for them. Yay, the state of Wisconsin will get to hear from me again. Won't they love that? Then, let's see, what was the other little gem? Now, I'm not sure how to get this convoluted portion of this mess figured out. But what appears to have happened is there were some ownership issues with this business. And during the litigation, the attorney who was litigating against the other group of people, that attorney should have become aware that there was this ownership issue. And I'm thinking that if you have a situation where one person in a litigation, you're all in theory on the same side, and one of the people on your side of the table with your lawyer is revealed to not be an owner because he went bankrupt and dissolved the company that held the shares. And per the operating agreement, which the attorney has, it says, per Wisconsin law, unless everybody plays kissy face ahead of time and agrees that it's okay, you're going bankrupt, you're still a member, you ain't a member. The opposition brought that up multiple times in the litigation. The attorneys, their attorney ignored it and seems to have, before litigation started, tried to get it addressed by sending them to a different attorney. So, if the case is these attorneys should have known that this one guy pretending to be the owner wasn't the owner, one, did they have an obligation to tell the other owners, hey, you've got a pretender here? And two, how do I prove it?
How would you prove that he wasn't an owner?
Well, no, we've got that.
Is that
prove that
what was that last question?
How do I prove that the attorney knew and then didn't tell the other owners? With the theory that they had, the attorney had an obligation, since who was contracted was the owners, to say, hey, you've got a pretender here.
Did the attorney have anything that could be construed as notice?
In the sense that the opposition filed multiple briefs saying this guy who's the pretender ain't the owner. I guess that's notice. That's
enough notice. So he had notice.
Right, good.
And this lawyer, was he a lawyer just for the imposter? Or was he a lawyer for the other clients?
For the firm, which would be the owners, and the imposter was also the president.
Okay, so he was a lawyer for the other litigants, but okay.
No. He was a lawyer for these guys in question.
Yeah. I mean, the guys he didn't give notice to, he was their lawyer.
Yes.
Okay, so here's the issue. How do you have standing to raise that issue?
Oh, I don't have standing to do squat other than help the people who didn't get told collect the money from the attorney.
Oh, okay. So the guys who didn't get told can certainly sue their attorney for malpractice.
Okay.
Definitely a remedy there.
Good. That's what I told them.
Okay, good. Do you have anything else for us?
I do have more follow-up on a 2014 show of yours. And about that.
Okay.
On the other side.
We'll be right back. Randy Kelton, Weave Law Radio. Call-in number 512-646-1984.
Why do Americans order extra large portions of food when smaller servings would suffice? I'm Dr. Catherine Albrecht, and in a moment I'll share an interesting new study that may shed some light on the psychology of overeating.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This public service announcement is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Food is one of life's great pleasures, but too much can lead to a host of problems like heart disease and diabetes. So why do Americans keep opting for enormous food portions? Northwestern University researchers think it has to do with class consciousness. Like cars and TVs, Americans equate larger food portions with higher social status. People told researchers that drinking a large coffee meant someone was probably wealthier than someone else drinking a small size, even when the price was the same. So it follows that people who are feeling poor may try to compensate with bigger portions. Sure enough, in experiments, lower-income folks were more likely to go for gutbuster sizes. I'm Dr. Catherine Albrecht. More news and information at CatherineAlbrecht.com.
Live Free Speech Radio, LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Real Star Radio, and we're talking to Mark in Wisconsin. Okay, Mark, you had more questions, or you had another comment on update on a 2014 show?
Sure. The 2014 show, you mentioned that there's a procedure beyond just filing generically the discovery, to invoke Toomsley and Iskwo, the pre-lawsuit discovery on the federal level. And I am not sure what to look for or a sample case so that I can then research and know what rabbit trail to run down. I know there are rabbits out there. I just don't know which brush pile I should be looking in. And
okay,
so
well, there is
brush pile.
There's pre-trial discovery in the Fed, but it only goes to depositions.
Okay.
It's not near as open as what it is in Texas.
Okay.
But I'm not sure what you're referring to. Toomsley Iqbal merely goes to the sufficiency of the pleading.
Oh, okay. Okay. Well, that's to give you an idea of how in the wilderness I am on that. I guess then I will look at the federal pre-lawsuit depositions now that I know that that's the rabbit trail I should be hunting as opposed to, depositions with Toomsley Iqbal there. So
I think it's Rule 76. It's Rule 70 something, and I believe it's Rule 76.
All right. Now I've got at least somewhere to hunt. The only other tidbit that I wanted some feedback on, once again, the group of lawyers that created the initial problem for me, besides them, and I'm trying to get the phrasing correct here so I don't blow it. Well, I guess it's escaped my head. I can always call in another show. All right, then. I guess that's all for me. Maybe your Truth Raider will be back and have something other than stories to tell. Any questions for
okay. Yeah, we are. The pastor on Truth Radio. For those of you who don't know, Monday nights I do a 1-hour show on Truth Radio Network. And Pastor Massett has taken over the whole network, but he is in Mexico. He has a couple of orphanages down there that he takes care of, and he's down there until the 18th.
Okay. Oh,
and we are upgrading his technology as well. Now, as I understand, didn't you used to broadcast in Madison?
No, I was out of Milwaukee and was unaware of the small radio station in Madison. There's a small radio station starting up in Milwaukee, and I'm going to be asking them and pointing them in your guys' direction. But I do now have the reframing on my question and looking for guidance on the other lawyers. Now, in the process of this whole mess that the listeners are probably not up to speed on. There was the issue in my small claims case. I brought up the issue of ownership. The ownership stuff was danced around, etc. But in the process, depositions and paperwork was issued with one of them, one of the gentlemen saying, I don't know who the owner is. So I'm wondering if the following occurred. The law firm that I have the big issue with was actually he was telling the truth. He didn't know who the owners were because the ownership was so convoluted. But in the process of trying to figure out the ownership, he received direction from the law firm that I have the problem with. And this is just supposition, and in that direction, he was instructed to take the keys for the business from the owners, just take the till from the daily till, put it in a new company, and just run with it. Now, if that is provable, do the people whose business were stolen and ultimately got back with a $1.9 million judgment, would they have a case against the original set of lawyers, the ones that I have the issue with? Because
did a court authorize them to dip in the till?
Nope. In fact, the state of Wisconsin law says if you have a reorganization of the company, it's like 183, 187. If you have a reorganization from LLC to Inc., you got to file paperwork. That paperwork was never filed. There doesn't seem to have been anything done. It was just one day the locks got changed and then the new banks were picked and a whole new company was picked.
Well, if the new company retained any of the old company's assets, absolutely. Now, this was a decision they took, so they're responsible. And they would owe it to the...
Yeah, certainly the gentleman who did this, who was the general manager and got fired and got sued, etc. But he doesn't have a circular copper vessel which to hold urine in, and so
or a glass wall through which to toss it.
Yes, that also a glass viewing portal for which to remove it from the room that one is in. Yes, so the question becomes: is the lawyers who may have told him be stupid like this, would they be possibly liable for that $1.9 million?
Absolutely
be me. All right. Oh, I am just going to be the bringer of joy and happiness all over.
These lawyers are likely not to send you a Christmas card next year. You understand that?
If they don't send me a Christmas card, it can go with all the other people who don't send me Christmas cards on my glass wall.
Your glass viewing portal.
Yes, my glass viewing portal. You put those Christmas cards up, it keeps the birds from hitting it over and over again and expecting a different outcome from the first time they hit the glass viewing portal. Yep.
Okay. Do you have anything else for us?
No. I believe I've gotten my information and hopefully provided enough entertainment for this evening. We'll let you go on to other callers, and may they also become entertained and educated.
Okay. Thank you, Mark. And don't be a stranger.
You betcha, sir. Bye-bye.
Okay. Now we're going back to Truth Raider in Oregon. Hello, Mr. Truth Raider.
Can you hear me, Randy?
Yes, I can. You had a couple more questions.
Good. Yes, no more stories. I have 3 questions for you. Concerning going to court, your testimony, when you said you snapped on that digital recorder after that judge became a little indignant and was threatening to throw you out of the court. Is that?
Oh, no. The court was not in session. The bailiff happened to be standing in the courtroom, and that's the only reason we were in there.
Okay. But it's not legal to use a recording device. I don't think they permit that in any way, shape, or form.
Yes. We weren't in court. We just happened to be in the room where court was held, but there was no court going on. And in Texas, I can record you even if you don't know it. But I just did that to annoy him.
Okay. And then, get his
that I literally did that as a pattern interruption. Certainly, he did not see that coming.
No. Okay, now the second question is, I went to court yesterday. This is concerning the most recent ticket. I've had 3 tickets this year. The first one is the one I talked to you about in the first segment that I was on the last time before we got disconnected. This is the 3rd ticket. The second one, well, that was similar, and then the judge did the same thing. He found me guilty and pay the clerk up front or set payments, and that's it. And I refused, and I just walked out. This one that I went to yesterday, this court appearance, the officer and we both gave our opening statements. We swore to tell the truth, the whole truth, and all that good stuff, and we had our opening statements. And during the course of that, when he was reading his statement...
Okay, hold on. We're about to go to break. This is Randy Kelton, Rule of Law Radio. Our call-in number, 512-646-1984. Steve Thomas, are you there? We'll get there, everybody. We'll be right back. Okay, we are back. Randy Kelton, Rule of Law Radio, and we're talking to Truth Raider. And you both gave your statements, you and the officer.
Thank you, Randy. Yes, and this is what he said. He made a comment, and I don't know if I should have objected to this or not, but he said, Your Honor, I feel that this individual is a danger to law enforcement, trying to exercise his traveling, whatever he claims is commercial sovereign travel. And should I have had that objected?
Objection. Absolutely.
Yeah.
You're not interested in his opinion.
Right. Well, that's what he was saying to the judge in the court. And I said, well, how does he know that? He's making an assumption. I've never been a problem to anybody in law enforcement. And I haven't even had a traffic ticket as far as moving violation in 16 years. My record's completely clear. I'm just not going to give out hundreds of dollars for nothing a month. They want to charge me $200 a month for insurance, and I can't afford that.
He said he considered you a danger?
yeah, consider me a considerable risk to law enforcement. You know, so much words what he said.
Oh, I would have loved to have cross-examined this guy.
Yeah.
What specifically is the nature of the risk that the act of invoking the law has on you?
Just my right of travel, for me exercising my right of travel, and just being defiant to the Department of Motor Vehicles and the transportation system, transportation code. I'm not part of the contract, and I refuse. As Thomas Jefferson, I believe, said, President Jefferson said, disobedience to tyranny is obedience to God.
And the courts have ruled that rights belong to the belligerent litigant.
Yes.
So you can.
So that should have been
the officer considers the exercise of a right to be a threat to law enforcement.
Right, because I pose a threat and a risk to law enforcement. This particular behavior and activities, what he said to the judge in so many words. I'm just trying to paraphrase the best he could, but that's how we articulated it.
That should get a professional conduct complaint. You should definitely file a complaint with his chief. Is he a city policeman or a county?
County sheriff, and he's a sergeant canine officer.
Ooh, file a complaint with the sheriff's department and with the county commissioner's court.
Okay, I will do that. The third question here, Randy, and I'll let you get on to other callers if they're anxiously waiting. I got this nice, this nastygram in the mail from Western Collection Bureau. And this is concerning the first case that I first talked to you about. Back the first ticket that I've gotten in 16 years. This is for a suspended registration and driving while suspended and not having insurance. This is the first one that I got. I got, as I said, the judge, just listened to what I had to say and then turned around and said, "Well, I pronounce you guilty, blah, blah, blah. Just talk to my clerk right here and sign the paperwork and we'll set payments up for you. That'll be all." Well, I refused, as I said, didn't sign anything. I said, I'm not going to do that. So I said, I want to appeal, but I don't have the funds to be able to appeal, and that's
Okay, we got that. You got a letter from a collection agency.
A collection agency, yeah. This is what proves that it's that it's civil and not criminal whatsoever. But this is what they've done. Now they're charging me $1,291.77, and that's for the one ticket, and the other ticket is $2,800. What is it? 2,000 and.
You send them a debt validation letter.
Yeah. Okay. So I sent them a debt validation letter?
Yeah, send them a debt validation letter. And they're going to say, we don't fall under. And you're going to say, yeah, you do. And then file a federal suit against them under FDCPA. Oh, and then contact them and say, let's make a deal, make this go away.
Okay. All right.
They want to fight, give them one. And you might look on Boulevard Radio or Logos Radio Network and go to the blue banner and click on Mike Miras. He'll show you how to do all that. And you might be able to get this law firm to pay you to go away and leave them alone.
That's what I'd like to do. Yeah, it's about $4,000 if you round it off.
Okay, well,
just total theft.
Well, click on the blue banner and get a hold of Mike Miras and talk to him, and he'll tell you what he thinks you can do on that.
Excellent. All right, Randy, that's that's my drama for now.
Okay, thank you. Okay, now we're going to go to Steve in Washington. Hello, Steve.
Hello, Randy. How are you doing?
I'm doing good. What do you have for us today?
Well, I've been listening to you guys talking, and it's like I totally disagree with the people calling in, like Truth Raider. I got to tell you, you're going past a lot of rules that are overlooked. And, I know people like to, maybe they want to not register their car, and, that's their choice. But the big deal is that there's a lot of information missing. Like, for one, if you're going to if you're going to get the ticket, and even though you have a certain time to respond, that doesn't mean to throw the paperwork out, because you still can file your civil claim, which you don't have to file it, but you need to write it, and it needs to be ready. And part of that is, if you're going to bring a civil claim, you're going to have to give them notice. So if you file your counterclaim, you can file it any time, and it's going to
wait. Counterclaim. He was in Oregon. In Oregon, is a traffic citation a civil or criminal action?
It's civil.
So it's strictly civil.
It's civil, yeah.
Oh,
As a matter of fact, they don't even have any. They're working on a law right now, which isn't a law. Basically, they want to change the code because there's no law to go back to on one of the cases that they're involved in right now. And they're lacking a lot of laws that they can enforce, actually. And really, they're just codifying, they're recodifying previous code. But my concern is figuring, you never figure that your paperwork is done. Okay, I'm going to toss this out. It's done with. I went past my limitation. It's not true because you're going to want to write your counterclaim, send it in, and it doesn't matter what they do with it because you're never going to win. But then that's your conditions precedent, and then you're going to want to write your 1983 claim, whether you missed the deadline or not, because now if something else happens and it's the same thing arising from the first instance, then now you're into secondary tolling, and so when you can bring that civil claim in, and then when you bring your civil claim in, normally it would be dismissed if you passed your limitations, but what will happen is you're going to have to file your ex parte for secondary tolling, and that's where you don't want to have a magistrate because tolling is a judicial construct, and that's going to have to be that'll be decided by a judicial officer. So you're going to file your ex parte, and then he's going to.
Okay, hold on, ex parte.
So,
what type of pleading? You're talking about a petition for a judicial. What do you call it? Where you're asking for a judicial determination. That's wait. How are you getting to ex parte? What are you filing ex parte?
Well, that's part of the rules of court is that if you bring in a claim that's past the limitation, you're going to.
Okay, hold on. Back up. Rules of what court? Washington State, Oregon, Fed.
The federal court.
Okay. In what instance can the judge hear something ex parte? The only thing I know of is emergency restraining order.
No, he can hear ex parte on tolling. Otherwise, he's going to make a decision on whether you can toll your limitation. And when you go past your.
Oh, okay, good. Because that makes sense because that's purely a matter of fact and law.
Right. Because
so it's not something they can get in and argue. Well, it's clearly
if he grants it,
you're asking him to say this action tolled the limitations, and what tolling means is it stops the clock from running. So he's going to be making that strictly on point of law. So that makes sense.
Right, and so that'll bring you back to your first claim that was barred by latches. So you never throw your paperwork out.
Okay, hold on. When we come back, I want to talk about how the first claim was barred by. How you're saying back to the first claim that was barred by latches. And when we come back, we'll explain what latches is. This is Randy Kelton, Real Law Radio. Our call-in number, 512-646-1984. We've got 1 hour left, and generally things build up toward the end. So if you're going to call in, do it quickly so I know how to time out each of these callers so that I get to everybody. Okay, we'll be right back.
How we're not gonna give in to the fear. Yeah, it's a story. I will lie by my father's house till he returns.
Okay, we are back. Randy Kelton, Blue Law Radio, and we're talking to Stephen Washington. Okay, when we went out, you referenced latches. And we're kind of working on that here in Texas. We filed a notice of rescission. stuck in at the bottom of a QWR, a qualified written request. We file a qualified written request. And if you look on the internet, you find all these qualified written requests. And what they really are is a request for discovery, because they got all this junk in there they're asking for. And mine asks for everything but the kitchen sink. And the lender has no obligation to abide by any of that stuff. But I do have a section on an accounting error. That's what makes it a QWR. And right at the bottom of this thing, after 20 pages of trash, there's this little paragraph that says that if you fail to validate the debt within 30 days of receipt of this note, you may consider this as notice of rescission. They never, ever read it. So that's their notice of rescission. After the 30-day period, then they got 20 days to either initiate the rescission process or file an opposition. Because they never read it. They never know to do that. So we claim that they had an opportunity, they had a right and an opportunity, but they sat on their rights. And that's what goes to laches. Where you had a right to do something and you failed to exercise that right, you waive it. Is that the way you understand laches, Steve?
Right. And if you fail to answer the claim, you have to answer that you go past the limitation, and now you're claim barred. And now the thing with traffic tickets is, if you have 2 traffic tickets, their policy is to mandatorily give you another ticket, and then now they don't use any discretion; they just give you tickets. So now you've got a good case, and you never want to throw any of these tickets or cases out. You want to finish them, keep them in your file, and get ready to make your case. I mean, most people just don't care. They don't want to bother with it. And the only other thing I can say is move to another town. Seriously. Aren't there people in Texas that...
No, wait a minute. Most people have busy lives, and we all choose our battles. I don't hold it against anyone who doesn't want to fight these issues.
That's true. If they don't want to fight, they don't want to fight. But I'm just saying, you got alternatives. And now I see guys talking about, we drive 2 hours to go around Tarrant County.
Yeah, that's Williamson County, just north of Austin. Alex Jones will drive 2 hours to go around Williamson County.
Yeah, right.
But,
I think that's pretty funny. But you know what? He's true. He's right. This guy, you're right. That's what you do, And when I was a little kid, when I was a teenager, my grandfather was a cop. Well, he wasn't a cop. They didn't have cops then. They had policemen and constables. And he used to say, he knew who was dirty, and he'd say, don't go here and don't go there and don't go out at a certain time of night. And I used to listen to him, because he knew. And that's what you do. You either, pay every time they see you, or move to another town, or sue, which is easier. Or, just pay and pay. You got to pick your battles, right?
Exactly, yeah. And, it used to be a lot of stuff about calling people sheeple, and I really objected to that because everybody has their own fights to deal with. There's a few of us who get out and fight these particular issues. But then there are a lot of issues that we're not addressing that other people are. And we don't have to have everybody doing it. If we got a few of them kicking them around, we tend to keep them honest. And I don't need everybody fighting these issues for me to get my part changed. If I can get 2 or 3 people in every county, I can get this done. So I don't hold it against somebody for not wanting to fight this fight. I have a driver's license. I keep one. I keep registration on my car. I got other fights to fight.
Right. You need a driver's license to rent a car. That's good for that. And I don't really think it's good for much other than, say, like I smack into you. You don't know me. So I show you my card and everything. And so now you're pretty well satisfied that you're going to get paid for your damages. But that's as far as that goes. And from what I see is, the towns are taking advantage of that and ripping people off.
Yeah, and that's okay. That is how it has always been. We grant power and authority to officials, and they will always abuse that power. I was listening to a program today that someone from Homeland Security was complaining because they needed these laws and more laws concerning gun control. And, I'm thinking, absolutely not. Yeah, you're stating a good reason for having them, but we cannot trust you. We know for certain if we grant you any right, you will abuse that right every way you possibly can. So we can't trust you, period. And it's the way public officials have always been. We have to police them. I was reading some Sumerian texts, and this is a book on the Sumerians, and they interpreted this plaque that was commissioned by an Akkadian king 5,500 years ago. And he was asserting that the purpose of the plaque was he was reasserting the old laws because those in positions of power and authority have so perverted the law that the citizen can no longer find justice. If this has been going on for 5,500 years that we know of, it's not going to change tomorrow. We're always going to have to fight this battle. If you and I, Steve, if we fix this, our grandkids are going to have to fix it again. This is not something we can't just get it fixed. We need to work on a system to where it's self-regulating. And that's why I'm pushing so much to get grand juries opened up. If a policeman happens to pull me over and I'm my usual obnoxious and demanding self and he decides to issue one of these attitude adjustments, if he has to look at explaining himself to a grand jury of my peers, he will be self-regulating.
Yeah.
So that's one of the things I'm working on.
Well, I was talking to a police commissioner, and he said that he recommended that 9 out of 10 graduates not be hired. And on the other hand, they hire all of them. And the reason is because if they don't get any funding. So they have a lot of people that are working as police.
And one of the problems with police work is the profession tends to draw people with personality traits that should keep them from being a policeman. The ones I would most like to see policemen is the one if you go to him and say, I want you to be a policeman, he'd say, heck no, I don't want to be no policeman. That's the guy I want carrying a gun. I don't want the guy that really wants to put a gun on his hip. I talked to an old DPS agent, a DPS officer here in Texas. He'd been on the DPS for 25 years, 30 years. And he was concerned, and he said these young local county sheriff's deputies, said they just can't wait to get in a gunfight. These guys should not be on the force. They have no business carrying a pistol. And they obviously haven't been in a gunfight. All you need to be in is one gunfight, and you're not going to want to do that again.
Well, hopefully not. I don't know about that. I mean, when I applied for the job, I applied to be a cop 40 years ago, and it was when I got out of the Marine Corps. And the first thing the chief said to me was, "How do you feel about guns?" I lived in Boston, and he decided that they just didn't want anybody to like guns or anything because they are very British.
Yeah, well, and that's...
I didn't get the job. Let's put it that way.
I kind of like that attitude that, he wants people that, they're not there so they can use a gun.
Right.
They're there.
That's exactly.
They find other ways to getting this done. Okay, do you have anything else for us? We're running out of time and we've got another caller.
Well, that's all. That was just on, I see a lot of mistakes. And one thing is if you're getting stuff from collection agencies in the mail, if you don't send it back as undeliverable or as unsolicited, then that opens up the mailbox rule, and you accepted that contract. That's what they call the mailbox rule.
If you actually have the mailbox and you don't accept it, the courts after 5 days will assume you got it. That's hard to get around. There's other ways of fighting these guys. You can go straight at them through the FDCPA, and Mike Mears is really good at that.
That's true, but when you open that envelope, it's yours.
Yeah, but that's not necessarily a problem because they screw everything up, and they know they're screwing everything up, but they make a lot of money doing it wrong. Every once in a while, somebody comes along and stings them, and that's okay. That's the cost of doing business. So we try to help as many people become their cost of doing business as possible. Okay, thank you, Steve.
Right.
We're going to break. This is Randy Kelton, Rule of Law Radio. A call-in number 512-646-1984. Tom, I see you there. We will pick you up on the other side. We've still got 45 minutes, so if you have a question or comment, give us a call. We'll be right back.
This is the Logos Radio Network.
Oh, come on.
Okay, we are back. Randy Kelton, Rule of Law Radio. And we're going to Tom in Texas. Hello, Tom. What do you have for us today?
Hey, good evening. Thanks for taking my call. I have a question concerning mortgage reassignment or mortgage assignment. I closed on a mortgage November 25th of this 2015, and they said it's going to be reassigned or sold or what have you. And I was instructed to make my first payment to this originator of the mortgage by January 4th. I got a letter in the mail from another mortgage company saying that they now had the mortgage, and I was to make the payment to them on or before January 4th. I checked with the land records, and the originator of the mortgage had filed with the land records here in Montgomery County, filed a note, or recorded a note, I should say, and I think a part of it was done with MERS, I believe, but and they had recorded it on by November 30th. Now here it is in January, and this new company, mortgage company, has not filed the assignment with Montgomery County. So I went to my originator and I gave them the check for it. I said, "Hey, look, I'm paying you because I have an agreement in writing to pay you this money by this date." I said, "I'm not paying this other company because it has not been recorded in the land records office." So I'm wondering, how should I go from here? Oh,
you're okay. It's in the. I'm trying to think of exactly where it's at, but I think it's in the the Real Estate Settlement Procedures Act. If there is a servicer and there's a change of servicer, and you pay your payment to the old servicer, they must forward it to the new servicer, and that's right in RESPA. So, from your perspective, paying the one that you're certain, the one that's in the record, you're safe.
Okay.
The one that claims to have an assignment but doesn't have one in the record, you don't know if they're real or not.
Well, I got a note from the originator of the mortgage saying, "Hey, we assigned this to this company," but they have never filed in the county records. I'm worried about future problems if I start giving them money and there's been no proper recording of the note.
Yeah, and that's exactly appropriate. But under the Real Estate Settlement Procedures Act, you're pretty well protected.
So I can just continue to pay the originator, and they're responsible to forward until. And I talked to the mortgager, the guy that had done it. And he said, "Okay, well, just pay me."
You shouldn't have any problem with that at all. And the lenders have kind of gotten things together. They're handling their business a whole lot better than they have in the last 15 years.
And an interesting note is when I had signed this, they told me I was under the old program, and the new one was taking effect, I guess, pretty quick. So I'm not sure what they meant by that, but I guess apparently I took my mortgage out under the old rules, whatever that means.
Yeah, I'm not aware that the rules have changed recently, at least from a legislative standpoint, but it may be rules within the company. So I wouldn't know what that was.
Okay, so there's nothing I need to worry about right now.
No, I wouldn't be concerned about it because with as much as the banks have been beaten up, as I look over foreclosure, the filings in the public record, these guys are getting a lot better at making all the filings the way they're supposed to. And there seem to be a whole lot less of the shenanigans going on. I do evaluations of the public records for people with mortgages. And if you have a mortgage that's before 2013, they are always a mess. But after 2013, the banks seem to have gotten things straightened out. And I don't find all of these multiple assignments and an assignment. I look in the record, I find an assignment from company A to company B. Then I find an assignment from company A to company C. So guys, you can't do that. Once you've assigned it, you don't hold it anymore. So don't you guys know what's going on? They don't know what's going on, or they didn't. After 2013, I don't find that kind of trash. Where a company assigns a substitute trustee, and then 2 days later they assign a substitute trustee again. They were just so incredibly sloppy for the last 15 years that it was just a horrible mess for the last 13. After 2013, they seem to get it together, so you probably won't have much difficulty. And certainly overpaying the payment to the prior servicer, that's right there in the Real Estate Settlement Procedures Act. That servicer is responsible to ensure the payment goes to whoever they assign to. They can't expect you to chase down their assignees.
Right.
So you don't have to be concerned about that part at all. If anything happens to those payments, you have a claim against the original servicer.
Okay, that's good to know because I was not wanting to get involved in another fight. I'm having too much fun fighting the courts on these traffic tickets. So,
Did you hear the first part of the show?
I did not. I just got off of work.
Okay, well, go back and listen to the first part of the show. I presented the rubber ball theory. And if you're having fun fighting these courts, this is an extra tool you can go in with to just drive these guys up the wall.
Well, the last time I was in court, they dropped the case, but it was right after I had told the attorney for the state, go read my motions, and then we can have an intelligent conversation. And
So he read the motions and decided he didn't want to go there.
It was a she, but yeah, I don't know if she did or not, but she dropped everything, and that was that.
Well, that's good. That's what we want to start seeing. I sent someone into court Thursday. The first time they went into court, the judge, he tried to read a statement onto the record, and the judge shouted him down, ruled against him, threw him out of the courtroom. So we go back and file my challenge to subject matter jurisdiction, and I walked right down the code and showed why Addison, Texas, an officer from Addison, Texas, could not be certified to enforce the transportation code, chapter and verse. And we filed a motion to recuse the judge for his unprofessional and uncivil behavior. They got into court this time, and they didn't take him last. They took him first. And the judge said that the motion to recuse was filed with the head administrative judge of the district, and the head administrative judge of the district denied recusal. Did that exactly the way they were supposed to. The hearing on the challenge subject matter jurisdiction was delayed for 4 months, puts it outside of statute of limitations, puts it outside speedy trial. Now he can move to dismiss. The way I read it, they're looking for a reason to dismiss this thing so they don't have to address it. And what the judge didn't know was in his hand he had 3 criminal complaints against the judge: witness tampering, obstruction of justice, official oppression. You want to have yourself a big mouth and a bad attitude? We see if we can't adjust your attitude. And it is a great way to learn the law. And it's a great way, you have all these people that want to be left alone. Just get them to leave you alone. You're in Montgomery?
Yeah, in a previous conversation, you'd asked me what did I want to achieve with I hear the music. Okay, I'll let you go. You've answered my question. Thanks for your time, Randy, and we'll talk to you again soon.
Okay, thank you very much. This is Randy Kelton, Rule Law Radio. We have one more segment and no more callers. So if you have a quick question, give us a call. We'll be right back.
For many people, life without tweeting, blogging, or emailing would be unimaginable. But did you know that 1 in 5 adults shuns the internet? I'm Dr. Catherine Albrecht, back to tell you who they are in a moment.
Privacy is under attack. When you give up data about yourself, you'll never get it back again. And once your privacy is gone, you'll find your freedoms will start to vanish too. So protect your rights, say no to surveillance, and keep your information to yourself. Privacy, it's worth hanging on to. This message is brought to you by StartPage.com, the private search engine alternative to Google, Yahoo, and Bing. Start over with StartPage.
Most people email, shop, and instant message through the web. But 1 in 5 Americans has never used the internet and has no desire to. The Pew Research Center reports that a stubborn subset of Americans is totally uninterested in email, YouTube, Facebook, or anything else that happens online. For the most part, they're senior citizens, minorities, the poor, and those with lower levels of education. If living without the web sounds impossible, consider this. Most of those surveyed didn't think they were missing out on much. Maybe those people treasure a world of real relationships and events and the freedom that goes with it. I'm Dr. Catherine Albrecht for StartPage.com, the world's most private search engine.
Actually be kidding about chemtrails.
You are listening to the Logos Radio Network. LogosRadioNetwork.com.
Okay, we are back. Randy Kelton, Rule Law Radio, and we're going to Rob in New Mexico. Hello, Rob.
Hello.
Hello. We can hear you. What do you have for us today?
Okay. Update on my multitude of cases. Interesting thing. On November 14th, I filed a notice of seller's default into the county record. I'm sorry. On November 14th, I filed suit against SunWest Trust, the fake escrow servicer. On November 15th, the notice of seller's default was filed into the county records. I'm wrong. October. Everything I just said, but October. The debt collector attorney that I sued under Fair Debt Collection Practices Act on October 22nd filed a notice of default electronically and electronically filed the special warranty deed conveying the property back to the seller. Now, this attorney came in after I sent a dispute letter and a request for accounting to SunWest Trust.
Wait a minute. A special warranty deed conveying the property back to the seller?
Mm-hmm.
Interesting.
So basically,
is there a contractual provision for that in your contract?
There is a provision to do that, but I believe that it has to be done by the seller. I don't think that the debt collector attorney can do that. I'm trying to look for it right here. But the fact that he did it after I filed against the escrow company for refusing to provide me with the information, I don't think that's going to look good for him, is it?
I wouldn't think so. That doesn't sound right. That's why I asked about a contractual provision.
If I'm looking right now,
this would bypass all the foreclosure laws.
Here's default by buyer. If seller or seller's agent delivers a default affidavit to the escrow agent, then escrow agent will release and deliver the escrow documents to the seller. Escrow agent will be entitled to rely on the default affidavit as conclusive proof of termination. So they have to give it back to the seller, then the seller can file the special warranty deed into the record. But it doesn't say anything about the debt collector attorney filing it in the record electronically, especially after I already sued the servicer.
Now, wait a minute. If I filed in the record a warranty deed transferring your property to me, what would you do?
I would challenge that.
I would think you'd call the sheriff and ask him to come and arrest me for trying to steal your property.
Well, what this does, though, is it conveys the property back to the seller. So the debt collector attorney didn't convey it to himself.
No, we don't care who we gave it to. So if I stole your property and gave it to somebody else, so what?
Okay. Well, I will get on that part there.
If this guy doesn't have authority to do that, that's conversion.
Yeah, that's what I was thinking. Now, another interesting deal is this goes way back. It's looking like these people never had title of the place in the first place. There was a special master's deed way back in 1988 after foreclosure, giving the property to, what is it? Hold on. Digging it out here. Giving the property to, where did it go? Plaza del Sol, I think was the name of the bank. Yeah, okay, Plaza National Bank was the name of it. Now, the next document filed is from Inter-America Bank, a state-chartered bank formerly known as Plaza National Bank, in 2001, giving the property for consideration paid to the people I bought it from.
Okay, well,
there's also,
if they're both the same bank, I don't see an issue.
Does there not need to be an assignment from Plaza National Bank to Inter-America?
Not if the bank changed its name and it's still the same company. Now, if the bank was bought out by somebody else, it would have to be.
Yeah, it would be bought out.
It's reasonable that there should be a provision in there to positively identify the holder, but just because it should be there, I've never seen one of that nature. I haven't seen anything in any of the codes that says if you, Randy Kelton, go down and file a deed of trust on this property or a warranty deed on this property, and then you go legally change your name, you have to come back here and file under your new name. I've never seen anything like that.
Okay.
So they probably can do what they've done.
Now, the other thing is that in 2001, I'm guessing, I don't have the date in front of me, but I'm guessing shortly after this warranty deed was issued, the Townsends took out a mortgage with Wells Fargo. There's no release of mortgage on the record. That was, 14 years ago?
Well, that's interesting.
It's possible that they got a short-term mortgage and paid it off, but I'm wondering if they have a mortgage on this place and didn't actually have clear title to sell it to me.
The record, if there is a mortgage and there is no release of lien, then the mortgage is still valid. I mean, the claim against the property is still valid.
Mm-hmm.
Well, so far as you're concerned, so far as the public record is concerned. Now, it may be a claim that can be argued, and maybe they just didn't file the release of lien, but as far as you're concerned, there's a claim against the title.
So how much should I ask for?
How much is the claim?
Mine, currently?
No, not yours. The one where they apparently took out a mortgage.
Oh, I don't have that information. I didn't actually get a copy. I just was talking on the phone to the county clerk, and she was digging through the records and giving me everything she could find.
Okay, yeah, just get a copy of that, and whatever the amount of that claim is, you add that to your claim.
Cool. Okay. Now, back to the attorney. Okay, aside from the possible conversion issue, back to SunWest, who was the alleged servicer and never proved anything, never answered my information request, and then I sued them already before the attorney filed these documents into the county record. So even if it's not conversion and he had authority to do that, wouldn't he be stopped from doing that by the fact that it was already in a legal dispute?
No, not unless he wouldn't be statutorily stopped. You would have to get a restraining order.
Okay.
And it's probably not a bad idea to ask for a restraining order anytime we file any action like this to keep the banks from moving the properties around.
Right. Well, we just had yesterday somebody from an insurance company come over taking pictures of the place. And my wife asked them what the heck they were doing and who they were, and they would not identify themselves. And she told them that the property was involved in litigation, and they got all agitated and took off. So I called the company, and the lady confirmed that they did have an insurance policy on the place. I asked her who was the insured. She would not tell me. And I informed her that there was litigation involved, and that if she didn't want to be involved in the litigation, she might want to reconsider her relationship with her client.
Okay, we are back. Randy Felton, Real Raw Radio, and we're talking to Rob in New Mexico. Okay. I don't think, from what I hear, that the insurance company is at any risk. Now, the insurance company is going to have to check and see who holds the claim on the property, because they wouldn't be able to, I couldn't come and get a insurance policy on your property, because then it would be valuable to me to burn it down. So for them to issue insurance, that may be why they file the warranty deed, in order to be able to put insurance on it.
That could very well be, and I'm I don't know what the heck they're doing. I can't figure out if these people are incredibly stupid or incredibly evil.
Yeah, well, if you live in this house, and now somebody has filed a bogus warranty deed, and now they've got insurance on the property, you're afraid they're going to burn it down with you in it.
Exactly.
So you might want to go to the sheriff and tell him, I'm concerned here. This stuff doesn't look good. That'd be great for the lawyer who did the transfer.
Mm-hmm. Have
you sent him a notice notifying him to rescind the warranty deal?
Well, I can't. Can I send him in? Shut up. Can I send that to him? I'm sorry, I've had a long, bad day, and I'm all frazzled. Can I send that to him, even though I already sued him?
Yeah.
Okay.
Yeah, you can order him to rescind that. It's a notice of tort. But I would go report it to the sheriff, to have the report on file that somebody has transferred your property, converted your property to their benefit, and they've filed an insurance policy on it, and you're living in the property, and you're concerned they're going to burn it down and collect the insurance and get rid of you in the same time.
Yeah.
That ought to be a hoot.
Yeah.
The story don't have to be true. It just has to be a good story.
Well, shoot, I don't know that it's not true. Like I said, I can't, this whole thing, they could have said way back when, hey, goofball, this isn't what happened with the insurance. This is what really happened. You're wrong. Let's fix it. They never did that. They just ignored everything I said.
Yeah. Well, you are a truck driver after all.
Right. Well, either they're incredibly stupid or they're incredibly evil, and this is all deliberate, and I can't figure out which.
Well, even if you really don't think they might burn the house down, can you risk that?
Heck no, not with my wife and kids there.
Right. So I would go straight to the sheriff. If you want the sheriff, come talk to him. And that'll probably get their attention.
All right.
Okay. Do you have anything else for us?
Affirmative defenses. Do they have to be pled, or can they just be named?
They must be pled.
Awesome. Okay. Now on an
okay, let me back up. Must they be pled or named? Have they named affirmative defenses in a response?
The affirmative defenses are: the petition fails in whole or in part for failure to state a claim upon which relief may be granted. Plaintiff's breach of contract claim fails for lack of privity and failure of consideration. Plaintiff's breach of contract claims fail for failure
to meet conditions. Fail for lack of privity?
Yeah.
Isn't your signature on that contract?
Yeah, last I checked, I was a party to the contract, so I don't know where.
Who did you sue?
Well, okay, I sued the seller. This is actually the answer from the broker and the real estate company. So it's the seller's son and her business that he's the owner of.
Are they named in the action?
Yes.
Oh, okay. But the fact that they're a broker and a real estate agency is not necessarily relevant. Are they parties to the transaction?
They're not parties to the actual contract, but they were parties in creating the contract, and I'm alleging that they assisted by their actions in breaching the contract or in causing a breach of the contract.
Okay, then the privity argument's irrelevant. Okay.
Now, then they say, material breaches of his obligations under the real estate contract excuse performance by other defendants. That's because I stopped paying after I sent them the notice of rescission. Plaintiff's claims fail under the equitable doctrine of unclean hands. Plaintiff's claims fail under the equitable doctrines of laches, waiver, and estoppel. Defendants deny any fault. To the extent fault is attributed to them, they are entitled to have a jury compare their fault with plaintiff and others under the doctrine of comparative fault. Plaintiff has failed to mitigate damages. No act or omission by these defendants has proximately caused plaintiff's alleged damages. Plaintiff's claims amount to malicious abuse of process. Plaintiff has failed to plead allegations of fraud with the requisite specificity required by the rules of civil procedure. Plaintiff's UPA claims are groundless, and defendants are entitled to recover attorney fees for defending against plaintiff's groundless claims. Plaintiff's claims are barred in whole or in part by the statute of frauds. Plaintiff's claims are barred in whole or in part by the parole evidence rule. And defendants reserve the right to supplement these affirmative defenses as discovery progresses in this case.
Okay, that sounds like kind of a standard denial, a standard response to a suit.
Mm-hmm.
So most of that's trash.
Right.
But I'd have to have it in front of me to be able to go through each one. But I didn't hear anything in there that sounded like it would get your suit dismissed.
So
that sounds good.
Move to strike for insufficiently pled affirmative defenses.
Okay, in order to do that, you need to show how they're insufficiently pled.
Oh, okay.
Yeah. But you may be able to do that. Any of them that are insufficiently pled, you can move to strike.
They don't state any facts to support them.
Actually, no, that's not a pleading. That's an answer. And all they have to do is deny.
Even on the affirmative defenses?
Now, the affirmative defenses, you have to look at the code, but I would expect they would have to plead the elements of the affirmative defense.
Right, that's what I thought. So, okay, now, can they realistically claim insufficient knowledge of matters that are of public record?
No.
Good. They claimed insufficient knowledge about their own license numbers.
That should ask for sanctions. Well, unless it's irrelevant. If their license number are publicly available, you can't ask for them because you have equal access.
Have what? No, I stated their license numbers in my statement of facts.
Oh, that's just a lawyer denying everything.
They claim to have insufficient
if you don't watch him, he'll deny his denial.
Mm-hmm.
Okay. It sounds like a lawyer's getting out of hand. He didn't want to stipulate to the license number. That's pretty stupid. Yeah. But it's also irrelevant, so I wouldn't even bring it up.
Okay.
It's bad enough that they're doing irrelevant crap. If you ignore the irrelevant crap, the judge is not going to think you're such you're pro se, but you're not doing the kind of trash they are. So you're pleading your case, defending your case, or prosecuting it better than they're defending. So that'll help you get over the pro se bias.
Okay.
Just don't go in there with a truck driver hat on.
Yeah, I was going to go in there with overalls.
Okay, so how long before you expect this thing to get to court?
idea. I've got this answer. There was a motion to dismiss from 2 of the other defendants. I just filed a motion in opposition to that. And then I've got 2 other motions to dismiss that just got filed on the 4th, and I don't actually have those yet. So I've got to respond to those, respond to them by the 19th, and, see what happens from there.
Okay. Well, wish you luck on it and kind of keep us up to date on how it goes.
Will do. So I'll be calling the sheriff's office tomorrow.
Okay. Oh, that ought to be fun. Okay. Thank you, Rob.
Thanks, Randy. Good night.
Okay. Jimmy, I am sorry. We are down to less than a minute. We're just not going to have time to get to you today. It's kind of hard when you call in really late. It's hard to get to everybody. This is Randy Kelton, Rule of Law Radio. We'll be back next Thursday with with Deborah Stevens on our regular Thursday night show at 8 p.m. Central, and then back again at 8 p.m. Central Friday for our 4-hour info marathon. And make sure you tune in to Monday for Eddie's traffic show from 8 to 10. Thank you all for listening, and good night.
I'm like a stepping